On June 25, 2026, the Supreme Court issued two immigration rulings that together represent one of the most sweeping expansions of unreviewable executive power in recent memory. Both were 6-3. Both were written by Justice Samuel Alito. The first, Mullin v. Doe, cleared the way for the Trump administration to end temporary protected status for approximately 350,000 Haitians and 6,000 Syrians and effectively shut the courthouse doors on statutory challenges to future TPS terminations. The second, Mullin v. Otro Lado, ruled that asylum seekers standing at the U.S. Mexico border on the Mexican side have not yet arrived in the United States and can therefore be turned away before they ever set foot on American soil. Both decisions handed the executive branch enormous power over immigration and removed the most common form of judicial check on that power. Subscribe right now because the human consequences of these two rulings are immediate, they are massive, and most people do not understand the full scope of what just happened. Let me start with what temporary protected status is, because you cannot understand this ruling without understanding the program it affects. Congress created TPS in 1990 as part of the Immigration Act of that year. The idea was simple and humane. Sometimes a country suffers a catastrophe, a civil war, a devastating earthquake, an epidemic, a political collapse that makes it genuinely dangerous for that country's nationals to return. In those circumstances, the United States would allow nationals from that country who were already here to stay temporarily, work legally, and build their lives without fear of deportation until conditions at home improved enough for safe return. The decision about whether to designate a country for TPS, extend an existing designation, or end a designation belongs to the Secretary of Homeland Security, who must assess country conditions and determine whether they meet the statutory criteria. As of 2026, approximately 1.3 million people from 17 countries hold TPS in the United States. Many have been here for years or decades. The TPS designation for El Salvador, for example, has been in place for over 25 years. Ukraine received TPS after Russia's full-scale invasion. Haiti received expanded TPS after the assassination of President Jovenel Moïse in July 2021 and the subsequent collapse of order in that country. Syria has held TPS since 2011, the year the Syrian civil war began, a war that has caused more than 500,000 deaths and the displacement of millions of people. TPS does not provide a path to citizenship. It provides the right to remain and work legally on a temporary basis. But for the 1.3 million people who hold it, it is the legal foundation of their entire lives in America. Their ability to work, their ability to drive, their ability to raise their children here without fear of deportation. When the Trump administration took office in January 2025, it began systematically ending TPS designations. The administration terminated every single TPS designation that came up for renewal. 13 in all. Countries whose TPS had been extended or renewed across multiple administrations, both Democratic and Republican, suddenly found those protections ended. Haiti's TPS termination was announced by then DHS Secretary Kristi Noem in June 2025. Syria's termination followed. Hundreds of thousands of people who had built lives in the United States faced the sudden prospect of losing their legal status and potentially facing deportation to countries many of them had not lived in for years or decades. Haitian and Syrian TPS holders fought back in court. Federal judges in Washington, D.C. and New York issued orders blocking the terminations. In February 2026, D.C. District Court Judge Ana C. Reyes issued a particularly notable ruling blocking the Haiti termination. Judge Reyes found that the termination was not merely a policy decision. She found that it was racially motivated. Her opinion quoted extensively from public statements made by Trump and administration officials about Haitian immigrants. She referenced Trump's repeated amplification of the Springfield, Ohio hoax, the false claim that Haitian immigrants were eating pets. She quoted DHS Secretary Noem's description of Haitian immigrants as leeches, entitlement junkies, and foreign invaders. Judge Reyes concluded that a decision made in this atmosphere of dehumanizing rhetoric could not be disentangled from racial motivation. The D.C. Circuit declined to pause Judge Reyes's ruling. The Trump administration went directly to the Supreme Court. The Supreme Court granted certiorari before judgment, meaning it agreed to hear the case before the Circuit Court had ruled, an extraordinary procedural step that reflects the administration's urgency in clearing the way for the terminations. Oral arguments were held on April 29, 2026. On June 25, 2026, the Supreme Court reversed the lower courts and ruled for the administration, 6-3. If you are finding this important, subscribe right now, because this ruling does not just affect Haiti and Syria, it affects every country on the TPS list, and potentially every immigrant program where Congress has restricted judicial review of executive decisions. Subscribe so you understand the full scope of what changed. Let me walk through Alito's majority opinion because the legal reasoning has two distinct parts, and both matter enormously. The first part is the core holding on judicial review. The TPS statute, 8 U.S.C. Section 1254A, B, 5A, contains a specific bar on judicial review. It states, and I am quoting directly, "There is no judicial review of any determination of the Attorney General with respect to the designation or termination or extension of a designation of a foreign state under this subsection." Alito held that this language means exactly what it says: no judicial review. The bar is clear and it is very broad. Courts cannot hear challenges to TPS termination decisions that rest on statutory grounds. Plaintiffs argued that the word determination in this context was a technical term with a narrow meaning. Alito rejected that. He said the word determination is used in its ordinary everyday sense throughout the TPS statute, not as a term of art with a restricted meaning. Therefore, the bar covers all determinations related to TPS designations, including terminations. No statutory claims can proceed. This holding removes the most powerful tool that TPS holders had to challenge terminations. The Administrative Procedure Act, which normally allows courts to review federal agency decisions for compliance with the law, has been effectively shut out. Courts cannot second-guess the Secretary's conclusion that country conditions have improved. Courts cannot review whether the Secretary followed the proper process. Courts cannot enforce compliance with the specific factors Congress directed the Secretary to consider. The executive branch's decisions about TPS are now, for practical purposes, unreviewable on statutory grounds. The second part of the opinion addresses the racial motivation claim that Judge Reyes had found so compelling. This is Part 3A of Alito's opinion, which was joined by Roberts, Thomas, and Kavanaugh, but not by Gorsuch and Barrett, making it a plurality rather than a majority on this specific point. Alito rejected the racial motivation argument. His reasoning: the Trump administration terminated every TPS designation that came up for renewal, 13 in total. This included countries whose populations are not overwhelmingly black. The administration's blanket opposition to the TPS program, as it had been implemented, provides a race-neutral explanation for the Haiti termination. Where a race-neutral explanation exists, Alito concluded, the equal protection claim is unlikely to succeed. This is the part that critics are calling sanitized and whitewashed. Judge Reyes had meticulously documented what administration officials said about Haitian immigrants. The majority accepted the race-neutral explanation, the across-the-board termination policy, and effectively set aside the documented rhetoric. Stanford law professor Lucas Guttentag, writing in Just Security, called the ruling a sweeping rejection of lawsuits challenging the Trump administration's summary termination of TPS and said the decision validates the administration's measure and undermines the rule of law. What the majority did not fully grapple with, critics say, is whether a policy of terminating all TPS designations is itself racially motivated if it is being pursued with racially charged rhetoric at every turn. That question was not resolved. The equal protection challenge can still go forward at the lower court level, but the majority signaled it is unlikely to succeed. Hey, 73% of people watching right now are not subscribed. This ruling affects 1.3 million people living and working legally in the United States. Subscribe right now so you understand every development as this plays out. Let me tell you what Justice Kagan's dissent says because it is important for understanding the stakes. Kagan, joined by Sotomayor and Jackson, would have allowed the lower court orders blocking the terminations to stand. Her dissent closes with words that are worth quoting in full. She wrote, "Respectfully, I dissent from the court's decision that TPS beneficiaries may be put on the next plane." That single sentence captures what is at stake in the most human terms possible. These are not abstract policy questions. These are people who have lived in the United States for years, in some cases decades. They have children born here who are American citizens. They have jobs. They pay taxes. They are part of their communities. And the ruling they have just received says they may be put on the next plane. Now let me explain the companion case, Mullin versus Otro Lado. decided the same day with the same vote by the same author. This case addresses a different but related question. Does an asylum seeker who presents themselves at a port of entry along the U.S. Mexico border but is physically standing on the Mexican side have a right to apply for asylum? Federal law says that any person who arrives in the United States may apply for asylum. The question is whether someone physically on the Mexican side of the border at a port of entry has arrived in the United States. The Obama administration developed a practice called metering, which limited the number of asylum seekers who would be processed on any given day. People who showed up seeking asylum were told to wait in Mexico until they could be processed. Otro Lado, a legal services organization, challenged this practice, arguing that people physically present at a port of entry on either side of the line had arrived in the United States for asylum purposes. Alito ruled for the government. He wrote that a person arrives in a destination only when they enter it. Simply reaching the threshold is not enough. You must cross it. He used an analogy. A running back does not arrive in the end zone when he is tackled at the 1-yard line. A guest does not arrive in a house when the door is locked before they open it. A letter does not arrive in the mailbox when a dog attacks the carrier a step away from the mailbox. A person arrives in the United States when they cross the border, not when they present themselves at it. Therefore, DHS can process asylum seekers on the Mexican side of the border and decline to let them cross before processing. Effectively, this rule allows border officers to turn people away without ever having to formally process their asylum claims. The practical impact of these two rulings together is enormous. Mullin versus Doe gives the executive branch the power to end legal status for over 1 million people without meaningful judicial oversight of its decision. Mullin versus Otro Lado gives the executive branch the power to prevent people from ever obtaining legal status by processing and turning them away before they cross the border. Together, they represent a dramatic narrowing of the legal space available to immigrants seeking protection and the courts that might have provided it. Let me now talk about what happens next for TPS holders. The terminations were expected to take effect within weeks of the June 25th ruling. Specific effective dates for each country will be published in the Federal Register. TPS holders who lose their status will also lose the work authorization that comes with it. They will need to explore other immigration options. These include family-based green card petitions if they have qualifying relatives, employment-based immigration if they have qualifying employers, asylum claims if they can meet that standard, other forms of humanitarian relief. None of these are quick or easy, and many TPS holders, particularly those who came from countries facing genuine ongoing crises, will find that no other immigration status is available to them. For Salvadoran TPS holders who have been here for 25 years, there's a particular tragic irony. They came to the United States after a catastrophic series of earthquakes. They built lives here. They raised children and grandchildren who are American citizens, and the legal justification for their presence has always been that their home country's conditions warranted humanitarian protection. Those conditions may have improved over 25 years, but the lives they have built here are deeply American. The ruling gives the government the power to terminate those protections, regardless of what that means for the individuals involved. For the 50,000 Ukrainian TPS holders, the situation is also stark. They received TPS after Russia invaded their country in 2022. The war is not over. Going home for many of them means going back to a country still under active bombardment. The Trump administration's blanket termination policy does not distinguish between countries whose conditions have genuinely improved and countries where the original grounds for TPS designation still very much apply. The Supreme Court has now said that decision belongs exclusively to the executive branch, not to the courts. The American Immigration Council summarized the broader implication with precision. It said that unless Congress takes steps to provide permanent legal status to TPS holders, hundreds of thousands are now vulnerable to losing work authorization and facing deportation. The ball is now in Congress's court. Only legislation providing a path to permanent status can protect TPS holders from the consequences of this ruling. Congress has considered various forms of legislation to address TPS holders' status over the years, including the American Dream and Promise Act, which would provide a pathway to permanent residence for certain TPS holders. Those efforts have repeatedly stalled. Whether this ruling provides the political impetus for congressional action is uncertain. What is certain is that the Supreme Court has closed the courthouse door on the most common legal challenges to TPS terminations. Courts may still hear constitutional claims, equal protection and due process claims, but they cannot hear statutory claims. And the majority's handling of the racial motivation issue signals that even constitutional claims face a high bar when the government can offer a facially race-neutral explanation for its actions. Representative Tom Tiffany, speaking after the ruling, said, "Over 14 years later, we are finally putting the T back in TPS." DHS General Counsel James Percival called it a win for the rule of law and common sense. Ohio Governor Mike DeWine, whose state has the largest Haitian immigrant population in the country and who had previously called the removal policy a mistake, said the ruling was a legal decision while reiterating his opposition to the underlying policy. The people most affected by the ruling are preparing for what comes next. Subscribe right now because the developments that follow this ruling will unfold over the coming weeks as termination notices are published, as TPS holders assess their options, and as Congress considers whether to act. This is one of the most consequential immigration law rulings in decades, and the human consequences are only beginning. This is educational content only, not legal advice. If you or someone you know holds TPS and is concerned about your status, consult an immigration attorney as soon as possible. The deadlines that follow from this ruling will be tight, and the options that remain require careful, individualized legal analysis.